Good morning, good morning, good morning. It's Thursday. The week is almost over. How are you doing, everybody? I hope you guys are doing well. Thank you for asking. Yesterday, I'm so sorry. I know I might have made some people a little nervous when I just ended abruptly. Okay, so what had happened was I just all of a sudden it came on like I got dizzy and I felt weak and I was kind of scared me a little bit. I think I'm just overtired and I'm feeling a little bit better today. We're going to get through this. But thank you guys for your concern. I'm sorry I ended like that. I didn't mean to scare anybody or worry anybody, but I am grateful that you guys do care and you are worried for me, but I'm okay. I just think it was, I just think there's a lot going on, just like YouTube wise for me, what I'm doing here, but there's also stuff that goes on in my actual, like real life or whatever. So sometimes when all of that collides, sometimes, Bendy's human. So, I'm sorry if I scared anybody. I'm okay. Um, I, whew, I think Sherilyn, this is really what it is. Sherilyn says, good to hear, Jen. You've put a lot of time into these videos. It's catching up to you. I do think it's catching up to me. I'm not as young as I once was, and I don't bounce back as quickly as I once did. So, yeah. It is what it is. I do need to take better care of myself. For the last week or so, normally my routine is 1 cup of coffee, 1 5-hour energy. Okay. Um, Although I don't take an extra 5-hour energy, I have had extra coffee, which 5-hour already has a bunch of caffeine in it as it is. So I think that might have been what it was. I'm not eating as I, I mean, I'm not eating great. That's another thing. Like I need to be an adult and I need to stop eating like my parents are out of town for the weekend. Okay. Like I can't, I actually need to eat a meal. Like snacks is not a meal. Um, so that's all. I'll be fine. I'll be fine. I need to do what I tell my kids to do. Okay. So that's it. That's all. I'll be all right. All right. Now, I really want to show something to you guys. I had a couple of things that I wanted to show to you, but I changed my mind on what order I'm going to show it in. I had intended this morning to start out with Fox 35 Orlando, which is the local news station that's been covering all the things Sarah Boone since all the things Sarah Boone happened. Um, they did an interview yesterday with a body language expert, and she had some really interesting things to say. She is attending the trial. So, one of the things that she said, which this is why I wanted to go, but we all know why I didn't go to the trial. So, one of the things that she said is it's very different viewing the trial in person versus viewing it online. You really get a sense of how small Sarah Boone actually is. She's not a big woman. She's not, yes, I think when you look at her in the body cam footage and even in the interrogation video, she's thin, but I think that honestly, she's a little underweight and kind of unhealthy. I think the Boone that we're seeing in the courtroom now is at a more healthy weight. And I'll tell you guys, as women, I can't speak to men because men just carry weight differently and age differently than women do. But for women, 110, 115 pounds on a 5'2" person at 20 looks very different than 115 pounds on somebody who is pushing 40. There was a time back, like in the before I turned 40. So I turned 40 in 2017. And when I was about 38, I decided, you know what, I'm way too chubby for what I like, and I'm going to lose weight. And I did. Um, but I got a little, like I overdid it and I lost too much weight. And I went down, I'm 5'3" and some change. I used to be 5'4". I've shrunk a little bit, but um, I was down to 110 pounds and pushing 40. I was about 30. I was 38 when that happened. And it looks very different on me at 38 than it did when I was, 18, pre-baby, pre any children. I fluctuated between 105 and 110, and that looks very different. And so I think what we're seeing on Sarah is she's put on weight, and I think she looks a little healthier weight wise. So that was interesting to hear from the from that interview, and we'll listen to that on break. Now, the other thing that she said that I thought was interesting was the way that the jury is made up. We know that it is there's only one gentleman, I believe, on the panel, but one of the women on the panel is a domestic violence survivor. And I thought that that was interesting because normally you would think um, you wouldn't want someone like that in a case like this on the jury. If you're the prosecutor, a person and the defense, really, a domestic violence survivor can be a double-edged sword as a juror. While they might be able to identify and empathize, sympathize with what the defendant has gone through. Okay, so that would be a negative for for the prosecutor and a positive for for the defense. Conversely, because they have experienced that, they might view Sarah as exaggerative, lying, um, all of those things, right? So that's why they're a double edged sword. Well, the body language expert was watching the jury, specifically that jury member during the defense's witness, Dr. Brannon, who is the battered spouse. They brought him in as a battered spouse syndrome expert. And apparently, she was listening extremely intently and even nodding at times. How will that translate into deliberations? I'm really not sure, to be honest with you. But this is what I really wanted to show you. And I want to do it quickly as I can because we're 4 minutes from court being in session. Okay. All right. This is a big one. All right. Y'all brace yourselves. And I'm so sorry that I'm bringing it to you late because this was filed on October 21st. And I normally am very good about checking the Orange County Court of Clerks website, and I didn't, and I feel awful about this. Okay. Are you ready? Let me make this bigger so you guys can read along. Let me see how this looks over here. Okay, let me move it. Let me do it like this. There we go. That's better. All right. State's request for in-camera hearing regarding financial arrangements between defendant and defense team. All right. This is the state of Florida. All right. The defendant is indigent. She had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving quote unquote costs money from JAC because of her indigency. Apparently, only investigator Billy Lane is being paid with JAC money. The defendant has secured the services of 4 attorneys and a jury trial consultant, and perhaps more that the state is unaware of at this time. The defense team is expending a tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for a several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida and then traveled back after it had passed. incurring additional costs. The state is concerned about a potential conflict of interest between the defendant and her team. Rules regulating the Florida Bar 4 through 1.4, 1.8d. The only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial arrangements between the defendant and her team. If there is an actual conflict, the defendant can waive this right with clear, unequivocal, and unambiguous language. Alessi versus State. For a waiver to be valid, the record must show that the defendant was aware of the conflict of interest, that the defendant realized the conflict of interest could affect the defense, and the defendant knew of the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial arrangement to ensure that there is no actual conflict of interest. And if there is unactual conflict of interest, the defendant validly waives any actual conflict of interest. Okay, so what is this about? Apparently, this stems from, just a minute, I want to read something really quick, check something really quick. Okay. Apparently, this stems from there being an alleged book deal, and that the financial agreement between James Owens and Sarah Boone is that, I guess, he obviously is the money goes to him in some capacity. Sarah, there is a Son of Sam law. It is a federal. Son of Sam is really tricky. Not all states participate in it. Federally, it's been ruled unconstitutional because of the First Amendment. It's all very complicated. There are many loopholes that people. There's a lot of loopholes. Okay, that there's ways around a person convicted of a crime selling their story. Okay, now I will tell you what can potentially be why the state is wanting to see this and how this could potentially impact the trial. The reason why the state is asking to see this is because should that exist, okay, if there was some type of deal, then the attorney has an additional agenda aside from just defending his client, okay? And in situations like this, what can result is in an appeals. It can result in appeals, and during the appeals process, what the appeal would be is this is something that happened during the West Memphis 3 case. Okay. Jesse, Jason, and Damien's attorneys allowed Jesse, Jason, and Damien to participate in the first documentary, which is Paradise Lost, the child murders at Robin Hood Hills. Okay. They were paid honorariums, and those honorariums went to the defense fund. Okay. So private investigator, stuff like that. Okay. Their appellate attorneys saw that as a conflict of interest. They saw that as these attorneys did not protect their clients. Instead, they allowed them to participate in a documentary where statements were given, stories were told, etc. And yet they had no control over what was aired, what wasn't aired, all of those things. So that is where the potential, no. where the potential conflict of interest can arise. Okay. And so that is why nothing, as far as I know, according to the website, the clerk's website, webpage, this in-camera hearing has not taken place. I know that I can find, okay? I know that there is, hold on a minute, I do want to show you guys this while we wait. Let me go over here. That I can find. Now, does that mean that nothing has happened yet? I don't know. I did see on News Nation, Ashley Banfield interviewed the owner of the YouTube channel Surviving the Survivor. And let me play that interview for you guys and see what happens, because we'll be learning this together. All right, here we go.
And let me just start by saying truth is definitely stranger than fiction. You can't make this up. So tonight, while I was podcasting my show, Surviving the Survivor, had to be sometime after 5:30 or 6 in the afternoon, the state filed an unbelievable motion, basically questioning a conflict of interest between Sarah Boone and her entire defense team. And that is because they are all working pro bono, except for the private investigator. She's got 4 attorneys and a jury consultant. And this motion is alleging that Sarah Boone is indigent. She has no money, so she's using taxpayer dollars to pay the private investigator. And then James Owens, allegedly, according to this motion, that he worked out some kind of deal with Sarah Boone to get the rights to her story. He could write a book, documentaries, movies. And so now the state is asking for an in-camera hearing tomorrow, meaning going into the judge's chambers, just the lawyers to disclose all the financial issues here. It could get ugly. This is a curveball that no one expected.
Woof. Yeah, that doesn't sound very good, especially when you're right in the middle of defending. I don't know about maybe later, if even that is ethical, but
Oh my gosh, I've been talking this whole time. Okay, so an in-camera hearing it really means out of the jury's presence. It doesn't always mean that it's in the judge's chambers. However, I suspect that because this is of a sensitive nature, that it probably most likely would be held in judge's chamber. What we will see on the website, I believe, would be the order, the end result, not what was testified to. Okay. So thank you, Jennifer. I appreciate that so much. Jennifer says, thank you, Jen Lou, for this commentary. I grew up as the daughter of an alcoholic mom, and Sarah sometimes triggers me because there was violence at times. Well, I'm sorry that you had to go through that as a child. Sarah is triggering to a lot of people, and that brings me to another point that I wanted to talk about with you guys before we get started. Today is expected to really be the last day of actual trial. Okay. The defense is expected to rest. The state is expected to begin their rebuttal and end their rebuttal. It should be, from what I understand from yesterday, it should be a fairly short rebuttal.
Case number 2020-2603, State of Florida versus Sarah Boone.
Hang on a minute.
For the record, beginning with the state.
David Cacciatore on behalf of the state. William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Can you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table, buttressed by her attorneys wearing a black suit and pink blouse. All members of our jury are present this morning, state, or is there anything we need to address before we bring in our panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is
Cordelia, that's a really good question. I haven't heard beyond the first day whether there was somebody there for him or not. So I can't really answer that, but I can try to find out for you.
June 16th, 2019, it's a no contact order. And identification to AC.
He's trying to admit this no contact order that occurred in June of 2019, the one that George violated, the one we've seen the arrest for.
And then I'd like to hand publish them to the jury.
Hand publish.
We got them on inside. And then I believe we're gonna rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Okay. So after the defense rests and the state puts on their rebuttal case, the state will rest. Okay. And then what's going to happen is obviously there are going to be motions that have been made that will be addressed, all of those things, right? Okay. But then after that is when they go into discussing the jury instructions. Okay. And normally I like to watch that, but, please don't be offended. I like to watch it alone. And here's why, because it's difficult for me just due to the makeup, the magic that is me. It's hard for me to focus on what's being said when I have to give commentary on what's being said. So probably what I'll do is when everything is said and done for the day, as far as the actual trial part goes, it's the motions and everything. Once they go into that part of it, I'll probably end the live. And what I'll do is I'll watch and then I'll take notes and I'll come back tonight and we'll talk about the jury instructions and some other things that I want to talk about with you guys, because I'm also I really want to hear from you guys. Now that we've watched the trial, all right, when it's all said and done, I want to hear how you guys are feeling about everything. I've been perusing the YouTubes, watching various things and reading comments and stuff like that. And at this point, it's where you'll have, let's say you have 10 comments. 5 comments will be, I don't understand what the state is doing. They should have pressed her harder. They went soft on her. They went easy on her. Okay, there'll be those 5, followed by 5 comments of, wait until they put on the rebuttal case. It's not over yet. It's not, so I want to hear when all is said and done and it's all over with and the jury has heard all of the evidence. I want to hear what you guys think. So, yes, Little Irish, I just went over that right at the beginning of the stream. I talked about that. Yeah, I heard. So yeah, this could be potentially it's potentially problematic only if Sarah says it's problematic. If Sarah is colloquied by the judge and she says, I know about it, I'm on board with it, it's fine, then that's that. There's nothing, she can still say later on, should she be convicted and decide to appeal the conviction, she can still change her mind later.
Do we want to do that now before we're going to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those 2 exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised. We'll use our time accordingly.
That was the 6th.
I don't believe so. Give me a moment and I can check. That is an alternate. It's alternate seat 4.
Thank you.
Defense, do you have any motions?
Hello.
Just out of abundance of caution, I would read new or motion for judgment of acquittal. Pursuant to Defense resting. We'll do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Mr. Beck, what's going on over here?
Is whether or not a reasonable trier of fact could find the defendant guilty.
That's right. Oh, God, you can't do it. Can y'all see that hair?
Thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those.
Okay. So Cordelia says, I'm confused. What is denied? Again, the defense made a motion for acquittal, basically citing that there is not enough evidence to support a charge of second-degree murder, and that a reasonable juror would not find her guilty. Okay. And then the state got up and said, no, a reasonable juror would find Sarah guilty of second-degree murder. And the judge said, you're right. I do find that a reasonable juror would find Sarah Boone guilty of second-degree murder. There's enough evidence to support that charge, and therefore we are proceeding. That's all that was. It's normal. Usually they don't do it twice, but here we are.
Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now.
Nothing important is really happening. We're going to go forward today. The defense is going to rest their case subject to 2 pieces of evidence, which are the
Is there anyone else? The email correspondence that I have is Mr. Owens's email.
The defense is going to rest their case subject to 2 pieces of evidence being admitted, 2 pieces being admitted as evidence and shown to the jury, which are the no contact orders from June of 2019. One is from the 16th, June 16th, 2019, and one is from June 19th, 2019. So that's nothing huge from them. And then the state will present their rebuttal.
All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
While they're standing and bringing in the panel, if you guys would take a moment to give your girl a thumbs up, I would greatly appreciate it. Please, please. Squirrel, I got your email, and yes, you're correct. And it is verified. I looked it up a while ago, maybe like a month ago at the end of September. I just wanted you to know that. I'll email you back. Also, to the person who emailed me yesterday morning, I got your email. I've
State you
read your
recognize our
email.
jury.
Yes,
I'm
Your
going to
Honor.
reply
Defense,
to
do you
you.
recognize our jury?
Yes, I do.
All right, thank you. Y'all can be seated.
Excuse me, Judge Koenig. I want to make sure that the person hears this. I did get that email yesterday morning and I did read it. And I want to thank you for reaching out and sharing with me, and I'll be responding. I just, yesterday was yesterday. We were all here. We don't need to rehash that. All right, here we go.
Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is defense exhibit 19. We'll just review it, pass it down.
I think that Owens is handing these out to the jury because obviously there's two no contact orders. And the reason there are two no contact orders is because George violated one. Now, that being said, I'm not sure if the jury is aware of the circumstances under which the violation occurred. I think they're seeing the black and white results, and that's all. Which is super annoying to me. I don't know what's contained in those So I don't know if in the second one, if there is a narrative along with it that explains what occurred and why there is a need for a second one. I think I have confidence in Mr. J. I think that he is going to, on rebuttal, if there is a little tiny crack of reasonable doubt, I do think he's going to close all of it all up and wrap it up and tie it into a nice bow for the jury. I have faith. Okay, so by the very strictest letter of the law. So Uncomfortably Numb says he didn't violate them. She invited him over, but called the police on him. Narcissistic BDP with sociopathic traits. Okay. Because the no contact order was placed on him, it's George's responsibility, because he's the only one that will be prosecuted for breaking that no contact order. It's incumbent on him to ignore Sarah Boone, right? And this is just going by the letter of the law, not using any, just strictest letter of the law. He's the one that will ultimately be punished for violating it, regardless of the circumstances. And so, he did violate it, unfortunately, by the strictest letter of the law. I agree with the assessment that she called him over and then ended up calling the cops on him. And we all saw that arrest and all those things and how she behaved, hollering, "George," and all the things that she did. It's unfortunate. It's still a violation. And it's sad. This whole situation that existed, the dynamic that existed between Sarah Boone and George, highly, highly dysfunctional, highly, highly toxic. And that is just who they are as human beings together. You mix in the oil and kerosene that is Sarah Boone and George Torres as individuals and mix them together. The alcohol is the fire, is the flame. I agree, Remy. I do think that it is crappy that the plaintiff can bait someone like that. However, you have to ignore her calling him over and over should play in my opinion. Here's the catch-22 about that. The battered spouse defense, or the battered spouse expert, testified that is common. And so this is where it's going to be a double-edged sword, right? If it all matters in how it's presented. And to be fair, we have seen many things that the jury has not seen. So our opinions are going to be very different than what the jury's opinions are. And so should Mr. J present that 2019 arrest video, right?
Thank you, members of the jury.
Owens is just going to come back and argue that this is part of the pattern with battered spouse syndrome. This is what happens.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you.
Good. Now sit down in your chair and be
Are you
quiet.
intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Speak with Dr. Tanya Warner.
Cordelia, I'm going to reserve my thoughts about the defense expert until after I hear Dr. Warner. Aw, Jennifer, I love that. Alice is not a fan of Sarah Boone. In fact, I'm going to say this really quickly about, I'm just going to mute this because we don't need to hear the swearing in. Alice the cat does not like Sarah Boone, and she is quite annoyed with the amount of time that I am spending covering this case, because she feels and has made a motion as such that my time would be better served serving her.
Here in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
A psychiatrist
And
can write
as a
prescriptions. A
licensed
psychologist
physician,
cannot.
Are you able to prescribe medication?
Yes, I am.
Yes, thank you,
In
Mr.
the
J.
course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
Also, good morning to you
And
guys just
When
joining
did
us.
you
Thank
begin
you
your
for
work
being
as a
here.
forensic psychologist or psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are.
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And Where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different. And so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, well, not strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there wearing a dark suit and a pinkish top.
May the record reflect she's identified the defendant.
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to make?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4:00 in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point, they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house. And then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. So, and she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If you refresh your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck two fingers out and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, Did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about,
Yes.
Okay, as you guys may or may not know, I still have like things that I have to do during the day, you know, so even when I'm streaming this, like for example, my son made dinner for all of us last night, and there were some dishes that needed to be washed. So while we were listening to the testimony this morning, that's what I was doing. And as I started, everything was going along swimmingly. And then all of a sudden my screen went black. So of course, what do? I haul my cookies over here to the stream to make sure all of the things are going like they should be. And they were. And so now I'm worried that the debug is back. And I don't need that kind of negativity. I really do not. Now, I'll say this, respective to what's going on currently with this testimony. I find this witness far more affable than the defense's expert witness. And this is just a personal thing for me. When the defense expert was testifying yesterday, her inflection at the end of everything she said, it's one of those things for me. It's like, okay, are you saying something? Or are you making a statement? Or are you asking a question? That is just for me. That's just a personal thing. And so I am JoJo. Thank you very much. It was just bothersome to me. And I did feel that in some of her explanations, she was a bit persnickety in her deliverance. While she was engaging the jury, which I always think is a good thing, there was something about all of this that her testimony that just didn't sit right with me. And so I find this witness much more affable. I think that this witness is addressing concerns that should be addressed. Her lapse in memory, the holes in her memory, that don't really make sense to us. For example, how can a person not remember taking one picture, 9 minutes later making a video, 11 minutes later after the video making a second video, yet remember what occurred prior to the picture being taken and what occurred in the 11-minute interim between the two videos? For me, that doesn't connect. It does not make sense to me. And I understand that memory is one of those things that's different from person to person. Some of us have better memory than others, just generally speaking. Other people, like myself, remember things like song lyrics, movie references, things like that, and hold on to those memories for a very, very long time, while other people don't. So memory is very subjective, but there are things, generally speaking, about memory that are sort of, across the board. And that incongruity makes no sense to me. And it is problematic. And Nessie is correct in this assessment. Nessie says, Neat Noodle, Juan testified on the stand that they called, and she said that in the background. unless Werner meant George didn't say it to Juan. And I think that's the point. The intent of that phone call to George's brother was for George to do the confessing. And when that wasn't happening, Sarah took it upon herself to speak in the background. Now, I'll say this. Sarah testified she wasn't yelling. I will say this. Sarah, while she was testifying, while her volume of her voice, the loudness of her voice was rather low, and it was relatively the same volume as in her interrogation videos. She's not she's not like a loud talker. It's just, her voice is a normal, reasonable volume. She doesn't speak loudly. I have a feeling, given that if Juan was able to hear her in the background, she more than likely her voice was raised. And to answer G. Delk, who says, stop saying jail expert. I don't think she's supposed to keep saying that. Okay. Initially, it was agreed upon that nobody would mention that Sarah is being held in the Orange County Jail awaiting trial and has been these last 4 ongoing, to use Sarah's phrase, ongoing 5 years. But Sarah mentioned it on the stand. And so now that ship has sailed. It is out. That ship has sailed. It is at the bottom of the ocean with the Nina, the Pinta, the Santa Maria, and the Titanic. It's done. It's over with. Sarah's the one that let the cat out of the bag. The end. I also kind of want to, so I think the plan is that closing arguments will be tomorrow morning, because I think that it was agreed upon yesterday that the jury instructions are very, very important, and I could not agree more. I think tonight we're just going to do like an overall recap. Maybe what we should do, maybe not an overall recap. Let me think what we'll do tonight. Probably we'll talk about the expert witness's testimony, and what I'd really like to do is highlight the criterion for battered spouse syndrome, and let's see whether Sarah checks the boxes, doesn't check the boxes, which boxes she checks. Like, I think that would be interesting to me. Would it be interesting to you guys? Is that something that you want to do? Let me know. Because obviously what's interesting to me is not always interesting to everybody else. And I want to talk about things that, you guys are interested in talking about. There is something, and I hope that Mr. J asks about this. Sarah's affect when recalling specific events. There are a couple of parts of Sarah's testimony where I think it would have been appropriate and acceptable for her to show some type of emotion, right? Even if I'm a person that compartmentalizes my emotions, especially when there's something important that I need to convey. So I will not become emotional because I want to be heard, and I want my thoughts and my words to come out clearly. Okay. So there's a small part of me that can understand her compartmentalizing some of her emotions, talking about the events of that evening into the next morning. On some level, I can understand that. However, when she's talking about George, when she and George met and the story of them falling in love, there was also an incredibly flat affect during that testimony. Her face didn't soften as she's recalling those days because those were the happy times, right? And I just, that part threw me for a little
Members
bit
of
of
the
a
jury,
loop.
thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next.
Oh, here
So
we
I appreciate
go.
your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
I agree, Rachel Lee. If there were some cats on this jury, this thing would be deliberated in 5 minutes, one and done. That's that. And I don't know what they're exactly arguing over this morning, but
Y'all can be seated. Thank you. Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes,
See,
think about it, process it.
this is why I don't care for Owens, okay? And I have to pause just for fair use and commentary. All right, look here, Mr. Owens. Even when you're asked the most simple question, which page? His answer always is served with stank attitude, and I'm over it. I just find him so incredibly rude and disrespectful.
But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I had.
Where's Nene Leaks when you need her?
Time to process on my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, But if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. And I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens. I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
All right, let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, that's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria.
Hang on a minute.
Question, line 17. Can you explain what?
Look here, Mr. Owens. Now, listen, I know that many people from the very moment that you took this case have been questioning your motives, okay? But all this extra that you're doing in an effort to prove that you're truly there for the right reasons, you are advocating for your client, is unnecessary, bruh. Stop it. This is a big fat waste of time. She didn't even get into any of this in her testimony because you interrupted. And now we're off on some side quest. This feels like one of those side quests when you're playing Mario that you heard on the internet exists, and you're trying to find it only to find out that it's absolutely a big, huge nothing burger. It's not an actual side quest. It doesn't actually exist at all. I need you to stop, Mr. Owens. You're getting on my nerves, and everybody else is.
What are the legal grounds of the objection?
He don't
I would
know.
not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me.
Oh, it's the judge's fault.
I would refuse to take that deposition. But under the promises from the state.
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial.
That's right.
What are the legal grounds of your objection?
See, this is why Judge Cranick ain't got nothing for Mr. Owens in this situation, because every single time there's a situation like this, Owens goes into the background information of everything that's ever happened since he's been on the case, like Judge Cranick wasn't there, attending every hearing, presiding over every hearing, ruling on every motion, like he's brand new. Tell him, Judge Cranick.
I understand the backdrop.
I don't know if there's a legal ground other than we had an agreement.
Oh.
As parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Hi, Ivelisse.
I don't appreciate the implications that they're making.
Tell him, Mr. J.
What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
I get
But
it.
the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a
I understand that, but that's
definitive
not the
no.
state attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant with the purposes of this argument.
Their discussions, and him feeling like it didn't apply.
As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed.
Okay, this is a very simple question that requires a very specific answer. He's asking what you want done, Mr. Owens, and here you come with, I don't know, and offering up 37 different possibilities of things that can be done. Pick one, bruh. Pick two. I don't care. Pick all 87, but just answer definitively. Stop answering a question with a question. It's so annoying.
Changed.
Sorry,
I
y'all.
think I have a right to take a second deposition.
Oh my
before she
God.
testifies.
Here we go.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
That's it. That's all.
Number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
Yeah.
That post-traumatic stress disorder doesn't apply in this case.
That's not a legal
Dr. Harper testified it did, and that's what
That's not a legal opinion. That is an expert witness in the field of forensic, in this case, psychiatry, and the other in the defense psychology. That's not a legal opinion, you big dummy.
I would like to have known that, and that was going to be her opinion before today.
Did you ask her that question?
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No.
No.
This is
No.
a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute,
Absolutely.
I'll read through it and find where I asked her.
There are four other attorneys.
Hey, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. The state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing.
Sure didn't. And by the way, where's your teammates, bruh? You got another attorney sitting next to you. You've got your clerks behind you. How are they not helping you?
So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Exactly.
Look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20.
Hey, everybody
Okay,
just
so
coming
other than
in.
the couple of
Good to
hours
see
that
you.
intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees.
Oh my God.
Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today.
Double
Line
dog
10,
sure.
that I've been asked about. If I'm asked something else, that I'll offer it. Number 12. Question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
There you have it. I don't understand your point, Owens. From now
I believe
on,
it's a discovery violation because I should have been notified if there was going to be a change in.
shut the fuck up. Okay. I believe from now on, anytime anybody asserts anything in my life from going forward from today, March, I don't even know what day it is. Look what you've done, Mr. Owens. Going forward from today, October 24th, 2024 at 10:21 a.m. local time, which is East Coast, Florida's time. I live on the Gulf Coast though, but obviously Eastern Standard Time. From now on, anybody that ever asserts anything to me and I feel that requires proof, I'm going to ask that the level of proof required is double dog sure from now on. This is not a discovery violation.
Opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial.
Ain't nobody ambush you, bruh.
What new opinions
Who?
are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Okay, he doesn't allow speaking objections, but the jury's been dismissed, so we're fine. But you're right, Tony. He doesn't allow speaking objections. That's why they go to the. That's why they go up to the judge's bench when there's an objection. But right now, he's got to hear him out. This judge is listen. Judge Kranick is incredibly fair, reasonable, and I think he's doing this out of an abundance of caution. He's going above and beyond. And unfortunately, Owens, it's going to be very difficult for people to understand your line of thinking and see your way of thinking, because no matter how good at yoga we are, none of us can get our own head up our butt as far as yours seems to be, bruh. It does seem like that, Ivelisse. It does seem like it does look staged and slightly set up. Yes, it
I'm
does.
just going to step off for a moment while Madam Court Reporter is able to provide that readback.
Well, the court might be stepping off, but your girl is going to step on the skip button. See where we go. Okay. You broke Judge Cranick, Owens. I hope you're happy. Look what you've done. What, B. Frank? Did y'all see YSL burning down yesterday? Defense deciding whether or not to take a mistrial without prejudice. All right, so the judge has excused himself. Probably, because the judge, God bless him, he cannot have outrage and episodes like I can. He has to remain professional, and he has to maintain court decorum at all times, whereas I am free to, oh no, that's not the one I wanted. Hold on. There's another ludicrous one that's that's act a fool. I need to add that one. Anywho, I'll add that later, but they're waiting now for Madam Court Reporter to review, to be able to pull up the exact verbiage, what exactly was asked and what exactly the answer was. Quite frankly, I don't understand how this is a discovery violation, because it seems to me, based on everything that we've heard in these last few minutes, that Mr. J is just as shocked by her answer to his question as Mr. Owens is. So this isn't something that the state knew about prior. Thus, it's not a discovery violation. And I'm over it. Like, I am just absolutely, completely, totally over it. I will say that when the body language expert was interviewed by Fox 35, she spoke about that video. And what she says occurred with the jury was that they watched it and they were not taking notes, which means that they were paying attention and not distracted. And I have a sneaking suspicion that they were left as confused by that video as we all were, because the video was played without any explanation. And the thing, if this is just my opinion, obviously, if the defense wanted to give context to that video, then the way that it should have been done is that piece of evidence should have been introduced into evidence when Sarah Boone took the stand, and it should have been played, and then she could have given the context, and it would have been left up to the jury to listen to what she said, see what was on the video, and weigh the evidence. That's, in my opinion, that's how it should have been done. If the defense wanted that video to be of any use to them, right? But the way that they did it was absolute poppycock, because that video, just the video being played with no context, no testimony, made no sense. Because the defense wanted to offer that in as an example of George being destructive and violent when he was drinking. Okay. And while it does show him inebriated and it does show him being destructive, he's not quite the belligerent person that Sarah described during her testimony about that incident, or that Sarah described in her interrogation video respective to that incident. And so, in my opinion, I think that video likely backfired on the defense. Utter poppycock, not just poppycock, not just regular poppycock. No. I'm using a enhancer, utter poppycock. Complete hogwash. Complete. Total hogwash. I think that the judge in this case, now let me say this. I believe had Sarah retained in whatever way she could, Mr. Owens, say after Mr. Horton withdrew and there was no Patricia Cashman in the interim, and he'd been on the case since the beginning of 2023 or mid 2023. I think that the judge would be patient with Owens, but not as patient as he's being. I think that Judge Kranick is incredibly fair-minded in that he is entertaining this objection out of an abundance of caution, and even helping in many aspects by saying, look, it's your responsibility. I'm not going to read 87 pages, bruh. You're the one that tendered the objection. It's the burden of proof is on you. Now either produce the burden of proof or sit down and hush up and let's get this show on the road. Instead, he's being very patient with him, and he did say the burden of proof is on you, and I'm going to excuse myself. I've heard what you said. I'm going to review it. I'm going to give the court reporter an opportunity so we can just settle this once and for all. It is what it is.
All right, we're back on the record. Case
Oh,
number
thank you,
2020 CF
Victoria.
2603,
I appreciate
State of
that,
Florida
babe.
versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens, Ms. Boone.
Kevin Beck, on behalf of Ms. Boone.
Ms. Boone is seated at council table wearing the same
Miss
clothing.
Buddha
from this
counts
morning.
as stable.
Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
Okay, let me answer Nessie. The objection that Owens is raising is that the expert witness's testimony is different than what she gave during the deposition. Essentially, he's arguing that Dr. Werner gave no opinion to any type of diagnosis, either PTSD, battered spouse syndrome, or narcissism, or narcissistic personality disorder during the deposition. And she cited the fact that she didn't have adequate time to process all of the things. Then, and his argument is that she's now testified differently, and that is what his objection is. I also object to Attorney Owens. I feel like for the remainder of the trial, as long as there is no he needs to sit down and be quiet while for the remainder of the testimony. Now, to be clear, I want you guys to understand that because Mr. Owens is the one who raised the objection, that means he's going to be the one on cross-examination. So brace yourselves. After all this arguing back and forth is over with, the testimony, the witness has passed, the torture for us is not over because Mr. Owens is going to be doing the cross-examination. All right, let's get back to court and hear.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as a defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion? Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may in the future, give an opinion about after some time reflecting and reviewing your notes. 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back. When it was first going on, when a question was asked, and I believe she rendered an opinion, and I, again, like that to be reread back. What the initial question was, what the response was, because it didn't, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
See, just interrupting for no damn reason. Where's Nene? You're up, Nene. See, every time the anybody in the courtroom speaks, the court reporter has to take it down. So when that happens, if he wants her to read the original question, which she's already asked and Judge Kranick has already said he would do, she has to then scroll. In her deposition, Mr. Owens asked Dr. Werner if she changed her opinion, would she let the attorneys know, and she agreed to. When Mr. J spoke to her this morning, she did not inform Mr. J as it relates to PTSD or battered spouse syndrome that her opinion had changed, because she had no opinion at the time of the deposition. Her opinion, so having no opinion to saying that she doesn't believe that Sarah suffered from PTSD or that battered spouse syndrome applies in this circumstance related to the way that Sarah relayed the incident to her, that would technically be a change from the deposition. However, it's not a discovery violation because she did not inform Mr. J. So he had no idea that she was going to testify the way that she testified respective to that question. That's it. That's all. Nessie said, oh wait, let me see what Nicholas said first so I can get that, because that we need to have the, okay. Nicholas says, Nessie, yes, I had never heard that one before. I'm assuming that's related to Judge Kranick's soup to nuts comment, which I also enjoyed.
Oh,
Then
I was waiting on you, please, go ahead. Sorry, pay no attention to me.
And then Nessie said, Nicholas, me either. I'm learning so much today. Double dog, sure, soup to nuts, debook. That is the quality content that you will be provided only at the ward case studies. And I'm happy to bring it to you. If you don't know what a debook is it's a Yiddish term. And it is a soul that is not at rest and can enter a living human being and devour the living human being from the inside out. If you want to know more about what a dybbuk does, Zach Baggins talks about it in his Halloween special when they visit the haunted horror museum that he owns. Also, the movie The Possession, starring the miracle national treasure that is, oh my gosh, what is his name? Jeffrey Dean Morgan. It is available on streaming platforms. I don't know if it's free or if it's for rent. I know it was on YouTube Movies at one point for free, but that's where you can see a full explanation of a dybbuk and what it does with visual examples. Let's carry on.
Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Would we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
Which is essentially how she answered Mr. Owens' question during deposition. We've had a request for Kai to make an appearance. And as you know, I'd love nothing more than to acquiesce to my chat, because after all, if it weren't for you, there would be no channel. So here we go.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash. Yeah.
And there you have it.
Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not.
Yep, that's on them.
Any
Tell
other
it.
argument?
The totality, if you read that deposition and all that we talked
I
about,
specifically asked you, Mr. Owens, to point out for me
I'm
what,
pointing out.
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, in the pages that I referred to.
The answer is no.
Our agreement that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369 Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
Mr. Owens, come on. He's speaking to you directly. Surely you had to consider what you wanted
And
done.
that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about
No,
post-traumatic stress.
no,
It's gonna
no.
come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the
Of
proffered
course she has. She
testimony and the
excels at
opinion
everything,
testimony?
including
And are
listening.
you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the
Oh my
proffered
God.
opinions, the court will oversee a deposition now, and you may proceed.
Depose
Yes.
her. No.
With regard to the
Oh my gosh. Y'all, the court will oversee now, Mr. Owens, now. No, another now. Later now.
proffered opinions.
I'm sorry, y'all, for my
And I
continued
believe that will
outbursts.
provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes.
is relating to a central issue in this case.
Correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J, anything else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses.
Look, I'm on shorthand for this for everybody. Here's the deal. Mr. Owens had this expert witness under deposition. He's an experienced attorney. To his own credit, he has said he has 35 years experience. In those 35 years, I would imagine Mr. Owens has taken a number of depositions. It is not the state's responsibility, nor is it the witness who you are deposing's responsibility to think of any and all questions you may or may not ask respective to her opinion in this case. If you want a specific answer, sir, you need to ask a specific question, which is just exactly what she told you when this new deposition took place. And now what you're doing is you're asking some vague, catch-all, cover my butt question, and you're expecting this expert witness to be able to read your mind about what opinion you may or may not want to hear come out of her mouth during the trial. If you want a specific opinion, you need to ask a specific question. That's what she's telling you. That's what she told you in the deposition. That's what she's telling you now. Get your poop in a group. I don't know if you need another shot of the Red Bull that you have sitting over there at your desk, but whatever it is that you need to do, get it together, bruh, and stop wasting time. Because I, as a taxpayer, is footing the bill along with everybody else in Florida. We're all footing the bill for this sideshow that you are embarking on, and I'm tired of it. Get it together.
You have to ask specific questions. Anytime you ask a question,
Oh, let's rewind that.
The expert's always going to say, please, they may or may not have.
Boone, who was on trial for murder in the second degree.
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge.
Yes, sir.
We're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here in the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
All right, can I continue with my deposition?
Please do.
Yes, sir.
We have all the
Dr.
time in the
Werner,
world. Ask a
You
specific
recall
question.
expressing that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder.
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards the adjustment disorder secondary to her situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
There was room for a follow-up there, but he didn't ask it. In my opinion, he should have asked when she said, as reported by her, he should have asked her to expound on that just a little bit, but he didn't.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
Oh, no.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can.
Before we bring the jury back in.
Oh my God.
Approach Mr. Cacciatore on a completely unrelated matter.
Does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us here in court this morning.
They're still under defense subpoena.
I
We
asked,
have not,
I asked Mr. Henderson if you guys were calling Detective Kepsel again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to seek sir rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But if
That doesn't
in
answer
fact,
my question. What's the legal basis of a sir rebuttal?
judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
The state is going to be allowed to finish. The testimony is going to continue. This is where jury instructions are going to be extremely, extremely important. Because I don't know if the jury can find that Sarah suffers from battered spouse syndrome, can they still find her guilty of second-degree murder? And this is where the jury instructions are going to be critical. I have to agree with Neat Noodle's assessment, and the court agrees with both Neat Noodle and I that Mr. J was not trying to hide this testimony, that Mr. J, as he spoke, addressed it with the court directly. And when he proffered the witness, he specifically asked her if she told him any of this during their conversations, and she said no. So I'm inclined to believe both the witness, Mr. J, and say that her answer was as surprising to Mr. J as it was to everybody else in the courtroom who heard it. I think it's going to come down to it's going to come down to jury instructions.
Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
I'm going to have to look into that. Little Red. Little Red says battered spouse syndrome instructions will give her rights to not be found guilty of second-degree murder. I'm going to look into that to make sure. Florida does things just slightly different, and so I want to be very clear on my understanding of that. And at this time, I'm not prepared for that argument at this moment. And I don't mean argument like in a negative way. I'm just, I'm not prepared to give an opinion yet.
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent, there was an imminent risk of harm that she needed to protect herself.
Yes.
All right, I've Googled the Florida bar, and let's see. Let me see what it says. All right, so let's see. Talks about the duty to retreat, which obviously in Florida, under this, there's no duty to retreat in Florida as it pertains to as it pertains to this case, because both people resided in the same home. Let's see. Let me see. I want to understand how it pertains to the jury instruction. So this is probably not the right article for me to read. So just in general, the question is, how is battered spouse? This is not the question I raised, or I asked Google, but this is one of under the people also ask, how is battered women's syndrome used in court? Defendants have also raised battered women's syndrome as part of duress defense in U.S. criminal proceedings. To prove duress, a battered woman must typically demonstrate a reasonable belief that her batterer intended to hurt her and that her behavior in violation of the law was necessary to avoid such harm. So, what is the jury instructions for necessity in Florida? An issue in this case is whether the defendant acted out of necessity in committing the crime charged. It is a defense to crime charged if the defendant acted out of necessity. Let's see. I'm just going to have to listen to the actual jury instruction that they give pertaining to this, because
Members of the jury, I have something I've got to discuss with counsel outside
oh
of
my
y'all's presence.
gosh.
Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you. Y'all can be seated. Thank you. Madam Court Reporter, when you're ready.
This is exhausting. I personally think that the jury is going to see through this. I think that they are going to find that Sarah does not actually have battered spouse syndrome, but that she is clearly a victim of domestic violence. I think that they're going to find that what she did was not justifiable, because it didn't start and this is where really the crux of it all is. How did Jorge Torres Jr. get into that suitcase? And the answer is, and this is in Sarah's own testimony, that they were playing hide and seek, that he got in there as the result of a game, that there wasn't any arguing, there was not a fight, there was not a precipitating instance of violence, aggression, threat of harm, any of that preceded him getting into this suitcase, that it all started out as a quote unquote game. And so I think the jury is going to see that while they can see that Sarah had been the victim of domestic violence, that her actions in this situation, as she has testified to them, do not meet the criteria for them to find that she has battered spouse syndrome, that she acted in self-defense, and therefore her actions, while against the law, are justifiable.
Answer, question, objection. Let's just have we can buttress it.
That's what I think.
Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or ESS, irrespective of that, based on your evaluation of Ms. Boone. What she relayed to you about the facts of this case, does PTSD or PSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Okay, just really quickly, I want to answer Wendy. So Wendy says he could have passed out and she put him in there and zipped it up. He may have woke up in it. Even his voice sounds like it. And while I think that is a potential theory, my opinion and what the jury that was not testified to in this case. And so I think that we can discuss it here for our purposes, but as far as the discussion or the things that I'm talking about, just like right now while we were waiting, is what the jury is going to find. And since there's no testimony of that, and in fact, the testimony is, and this comes directly from Sarah herself through many, many sources, whether it be her direct testimony or the interrogation video, the events that precipitated all of this were of a game. Everybody, it was a good day. It was all in fun. That is essentially what, I mean, this is it. I got to say, it was a good day. That about sums it up. She did not put him in that suitcase like because they had had an argument and she struck him with the baseball bat and rendered him unconscious and then put him in the suitcase to contain him and then he died as a result. That's not what she testified to. And so the jury's not going to, they're not allowed to consider that. It's not even a theory that had been brought up by either side. They can only they can only render a verdict based on the evidence. So I feel like, while I think that's probably a good theory, the jury is not going to find that. I think the jury is going to weigh the evidence based on Sarah's testimony about what occurred that day, because that's the crux of the situation. She was not in imminent danger when George was in that suitcase.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen.
That is not what she said.
That under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Poppycock.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong.
That's your argument.
The prosecutor claims Dr. Harper came in and said BSS does apply.
She did.
That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded.
That's not what he
It
asked.
doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome.
Okay, Owens, listen, I don't know if you're being intentionally obtuse or if this is just you're actually not comprehending what it is that was asked. Okay? Because this is absolutely ridiculous. She's not giving a legal opinion. He's asking her if irrespective of any other diagnosis, that's what he's asking her. Stop it. Like you're really arguing what the meaning of is in this situation. And I've had enough.
Does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
That's not what he
Does that have anything
said.
to do with whether or not it's an improper legal opinion under 90.703?
It doesn't.
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer, and then I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for mine.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
Yes, this is absolute. I mean, I get it. He's trying, but it's like at this point, I just can't. I'm sorry. And Wendy says she just can't tell the truth. Was that she just wanted to kill him, and she could, and she did. And I know that in that 911 call, she does say that she put him in the suitcase. Okay. But she said it only that one time. And every other statement that she's given after that has been consistent. So the state is really in a rock and a hard place. It would be very difficult to prove based on the available evidence. And by that, I mean the photographs of Sarah, the statement she gave in interrogation, all of those things. And also, but most importantly is the autopsy report. Okay. And the medical examiner says that everything sort of occurred around the same time, respective to the bruising. However, the bruising.
Do you recognize our jury? Defense, do you recognize our jury? You may be.
The bruising that was a result of blunt force trauma. Although it occurred around the same time as death, it was not those injuries themselves were not fatal. They're not the cause of his death. The cause of his death was being in the suitcase. And so I think that is why they're not talking about it. That's why they're not hammering on how he got into the suitcase in the first place, because it's very difficult to prove. There's no evidence that's been provided or really could be provided. There's no diazepam in his system, no benzodiazepines of any type. So I think that is the situation. Now, Cordelia asks, so that means Warner is more credible than Harper. That will be up for the jury to decide which expert witness they believe is more credible. And because her testimony thus far has been so disjointed, thank you, Owens. It's going to take me a minute to process everything that she has said. And LGS, thank you very much for becoming a member. Welcome to the ward. Happy to have you. Thank you for your support to me and of me and the channel. I appreciate it very, very much. All right, let's get back to what we're here for, which is testimony and not Owens making objections and outbursts.
Be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Well, I just want to answer this really quickly from Rachel Lee. Sorry, you're not stupid. Don't say that. Rachel Lee asks, why did they send the detectives home? They didn't just send the detectives home. They removed the detectives. They asked the detectives to leave the court. And here's why. You can't, as a witness in this proceeding, the rule of sequestration as it applies to witnesses was evoked. What that means is a witness in this trial cannot sit in the gallery until they have been released from their subpoena. Now, they were not released from their subpoena at the end of the day. Okay, so they're not allowed to sit and watch the trial as it goes on. The state released them from their subpoena. However, the defense did not. And so therefore, they're not allowed to sit in the court until they are released from their subpoena. And now there's a potential that they're going to make a motion to rebut the rebuttal.
Request to read back the question and answer.
Madam Court Reporter.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and DSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk of harm.
No further questions.
Any cross-examination?
Yes.
You may proceed, sir.
Dr. Warner, good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
Correct. I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, you approach?
Yes.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
All right, look, Mr. Owens, this is really not that deep. What she's testifying to is, oh, I need to turn my phone down. Sorry about that, you guys. Nobody needs to hear Jen Lou twice. Whew. All right. This is what she's saying. This is very, very simple. This is not that complicated and it's not that deep. She reviewed all of the material that was provided to her by the state and you, I would imagine. Okay. At the end of the day, the reason that that her opinion is what it is based on ultimately what your client, Sarah Boone, related to her about the events of that day, specifically that the way that Jorge Torres Jr. got into that suitcase was as the result of a game and fun, not an argument or a threat or violence or a threat of violence. The end. It's not that complicated. And all you're doing is muddying the waters, and it's not going to work in your favor at the end of the day. The jury is going to see through this baloney. I have faith. Owens can attempt at leaving no room for interpretation, but at the end of the day, the jury is going to interpret the testimony the way they're human. All human beings interpret information, period. You know, it's no different than if we all walked outside, if we were all standing in the exact same spot, right? And we all looked up at the sky at the exact same time, okay? Some might say that the color of the sky is blue. Another person might say the color of the sky is powder blue. Another person might say that the color of the sky is cerulean. I mean, it's all based on interpretation, but at the end of the day, they're all shades of blue, okay? So it is just what it is. And this is ridiculous. And it's an incredible waste of time. Let her say what she's going to say. Let her testify how she's going to testify. and let's be done with it. For me personally, after hearing everything in this case, it's my personal opinion based on everything that while, yes, Sarah was a victim of domestic violence, of interpersonal partner violence, so was George. Sarah, in my opinion, does not have battered spouse syndrome. Okay. While she might have PTSD, I feel like the PTSD is probably something that is unrelated to George, and I'll give you a reason why. And it's something that this witness testified to very early on under direct. When she was testifying about Sarah's narration of what occurred that day, one of the things that Sarah said, and she's testified to this as well, Sarah herself, is that there was a phone call made by George to his brother, or to his children. Okay. There were phone calls. Whether they were answered or not doesn't matter, because it's the fact that the phone calls occurred. An attempt to contact occurred at the suggestion of one Sarah Boone. Even though Sarah is well aware, because she's testified to it, that his daughters don't like to speak to him when he's been drinking, and they had both been drinking at that point, she still suggested an action to George, which he did, that could have resulted in triggering George, as it were, which thus then may have, as she's testified, George gets angry, George is out of control, George is violent when he has been drinking. So why in the actual F would you ever suggest an activity that you know is going to trigger your abuser? That's the point. That's why I don't think that she has battered spouse syndrome. And and the jury can agree that while she was a victim of domestic violence, that she does not qualify for the battered spouse defense. There are many things that Sarah Boone has done that are not indicative of a person with battered spouse syndrome. For example, the power dynamic that existed between the two of them with respect to the finances. Sarah is the one that had the money. And even if you just take that, just not their whole life together, the whole time they were in a relationship together, but just that day, how did the alcohol get purchased in the first place? Well, it was Sarah driving George to the Publix the first time, Sarah paying for the alcohol the first time. Second time George went to Publix and to the convenience store to get cigarettes, it was Sarah's car he used and Sarah's debit card that he used to pay for the purchase, meaning Sarah holds the purse strings. All right. Then you have the other power dynamic. George didn't have a vehicle. What did he have? He had a bike. Who gave him that bike? Sarah Boone. George didn't have a working telephone. I'm meaning that it couldn't, theoretically, if he were on Wi-Fi, he could make a phone call. He could make he could have a text message, right? He could send a text message and receive text messages, but he didn't use his phone for that. Whose phone did he use to contact his family? Sarah Boone's, which means effectively she was the person in control of George communicating with outside people not living in that home, people that were not Sarah Boone. So there's Those two power dynamics.
Objections overruled. You may proceed.
Thank you, Judge. Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes.
And we discussed that these were the phone records from Sarah Boone's phone.
Yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
Correct.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5. Approach.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk.
read my
First, you
complete
said
answer.
no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, need to object. We need to approach.
All right. Owens is trying to elicit some testimony that paints Dr. Werner as essentially he's trying to get her to say, after I read those text messages, I changed my mind. Or I found them to be irrelevant. And he's trying to paint her as what's the word I'm looking for? Incompetent is the word that I want to use, but I don't know if that's quite exactly what he's trying to do. He's trying to diminish her credibility in front of the jury, quite frankly. And the fact of the matter is, and Owens can like it or lump it at this point, but just because Sarah was in a volatile, violent relationship with Jorge Torres Jr. does not necessarily mean that she has battered spouse syndrome. There are other criteria that come into play that in this doctor's opinion, based on the interview that she conducted with Sarah, as well as all the documents and anything that the state or anybody else gave her that are relevant, that they've deemed relevant, she reviewed and she based her determination that because of the fact that what occurred, what started all of these events, what started the chain of events that ultimately resulted in Jorge Torres's death was not violent, argumentative, threatening. It was a game. Everybody was laughing and having a good time. By Sarah's own admission, both to the doctor and in her testimony, i.e., it was a good day. That's it. That's all. And he's not happy with her answer, and he wants her to change her answer, and she's not gonna. At the rate this is going, this trial is going to last another week. Oh, Kaza, that's an interesting, let's read Kaza's opinion. Kaza said she spoke to her 2 hours and looked at limited information. Not sure she is a totally credible witness. This will be a long cross-examination. You're not wrong. That is true. She did speak with her for 2 hours. She did look at limited information. I do think this is the part I agree that it's going to be a long cross-examination. I also think that she is a credible witness. I think she's more than qualified. I think that I think that I think I'm going to wait and see how this goes. I'm going to take a wait and see approach. And I would like to read, let's see what else you guys are saying. Mark Milligan says, I think you're forgetting he has to try and get the jury to look more favorable.
It is 11:55. At this point in time, we're going to go ahead and take our lunch break.
Fantastic. Okay, so Mark says, I think you're forgetting he has to try and get the jury to look more favorable to the defense expert, and personally, he is doing a great job of it. It's his job. It is his job to discredit the witness on the stand. That is correct. It is his job also to call her credibility into question, and I'm not arguing that that is not his job. But you have to be careful when you do it. And you have to be careful in the way that you do it and the tone that you use. While your assessment of the job he's doing is favorable, it is also very possible that because his tone is what it is, that to the jury, it's coming across as argumentative and combative and a little badgering. We just don't know. We just don't know at this time how the jury is reading into it. All right, hold on. They're going to take their break at lunch. Sarah's going to be, and they're going to, that's that. Wow. Oh, Little Red says, here is my thought. If any one of the jurors hear that both experts saw battered wife syndrome, that changes their thoughts. You're correct. If we ever get to the point in her cross-examination where she says that it's possible that Sarah had battered spouse syndrome, then yes, it's going to play into the into all of this. And it could definitely change their opinion. However, it's equally possible because let's say Owens elicits that response from the witness. Okay. It is also entirely possible that they don't find either witness credible, the state or the defense witness credible, and that they don't give the state expert witness or the defense expert witness's testimony much weight in light of the video, right? The suitcase video. That's also possible. And that is something that might actually happen because at the end of the day, right, I think that both experts have testified and would agree. I know that the defense's expert witness was asked this on cross. Essentially, she was asked about the motivation of the defendant or the person that she's interviewing or evaluating have a motive to be less than honest, okay? To over-report or under-report, okay? And I think that it is quite possible that the jury can hear that testimony and say, okay, you know what? We're going to rely solely based on what occurred that day, what Sarah said occurred that day, and what the suitcase video shows occurred that day. That's all we got. That's the most important evidence, right? And they look at that video and they look at, and they reflect or reread or whatever it is however they do it on Sarah's testimony. And you can see there's a very clear difference in the demeanor and the behavior of Sarah Boone in the Suitcase videos versus how she testified on the stand about how she was feeling and what she was thinking. And that's entirely possible. We just don't know how the jury is going to, what weight the jury will put on the evidence that they've heard. You know, yes, expert witness testimony is fantastic. And it explains a lot. It explains the complicated issues to juries. But at the end of the day, it's up to the jury how much weight, if any, they give all of the evidence, each piece of the evidence. And the only evidence, in my opinion, that isn't really subjective is that video, or those two videos, frankly. So we'll have to wait and see. We'll have to wait and see. So they're going to take their lunch. I really thought that we would be in a much better place at this point. I thought we would be further along, and now I'm not really sure what to do. I'm not really sure how I want to proceed. I think what I'm going to do is end this and recap this tonight rather than do it live. I think that's what I'm going to do. I think that we need a break. So maybe what I'll do is I'm going to take a break, but I'll be back. I'm just not exactly sure what time that will be. I think this is a good suggestion. Rachel says maybe reconvene later this evening. Let's do that. So make sure that you have your notifications set to all so that you'll be notified of that I've scheduled a live. And then you obviously would want to turn your notification on once you see the live, turn your notification bell on inside of the live so that you'll know exactly when I go live, and we'll do that. And thank you, Kentucky Lee. I appreciate that, babe. Thank you for becoming a member. Welcome to the ward. Thank you for supporting me and the channel. I appreciate that very, very much. I think that's what I'm going to do. And this way we can sort of skip through all of the pauses and the things like that and talk about it. So we'll do that. And this is a good closing thought. So Carolina Hurtado says, at Joseph Jen Liu, remember 22 days ago, Sarah Boone spoke to Dr. Warner and never told her that she was in fear of Jorge Torres Jr. And that's very important. Hugely important, because the state evaluated Sarah well after the defense did. And there were opportunities in between both evaluations. And Sarah did meet with James Owens. So there you have it. You guys have a fantastic rest of your day, and I will see y'all in a little while later this evening. And thank you guys for being here. And if you haven't done so, please give your girl a thumbs up on the stream. It gets us in the algorithm, and we get new people in here from that. And it's always nice to meet new people. All right. Thank you for joining today. Have a fantastic rest of your day, and I'll see y'all in a little bit. I'll see you guys in a little bit. All right. Have a great day. Bye.